Hi, I'm Jerry Kroll, and this is Legal Las Vegas, where we pull back the curtain on the mystery of what goes on behind those courtroom doors. We're here in Las Vegas, Nevada, because this is the gambling capital. But the reality is that courtroom trials and casino gambling have something in common. It's called probabilities. What's the probability of rolling a 7 or an 11? What's the probability of getting a jury verdict in a courtroom trial? That's what we talk about here. Because when you walk through those courtroom doors, anything can happen. And sometimes it does. We got the truck, got the Airstream. We're going to hit the road because we're going to talk to the people who really know what goes on. So strap yourself in, get ready, relax. We're going to roll the dice together and take a chance. I brought my Airstream here today to an undisclosed location in the western United States so that we can interview one of the nation's top trial lawyers to get some insight. It's Arthur Bryant. Arthur, it is so good to see you.
It's a pleasure.
Such good to see you. You know, they say that lightning doesn't strike in the same place twice. Well, in Arthur's case, it did. He has twice been named by the National Law Journal as one of the top 100 most influential lawyers in America. Welcome, Arthur. It's such a so good to see
Thank
you.
you.
Thank you so much. You know, part of why I was so thrilled to see you is because, you know, we talk to a lot of people about the law and probabilities and rolling the dice. And a lot of times people are rolling the dice and it's about money and it's about lawyers and money. And you're in a totally different field, Arthur. You're a public interest lawyer. Okay. How did you get into this in the first place?
Well, I wanted to be a public interest lawyer since I was 14 years old. I thought I wanted to make a difference in the world. And the best way I could see to do that was to practice law and to fight for justice.
So this is like a childhood passion come true.
Exactly.
You know, because it's like most, you know, what did I want to be? A fireman? Okay. And obviously that didn't work out very well.
There we go.
I mean, I wanted to be everything. A researcher, but you actually are doing what you wanted to do since you were 14. It's amazing.
Oh, yeah. I mean, look, from my perspective, the purpose of the law is to do justice. And you can't have a better legal career than to spend your legal career fighting for justice. And that's what it should be all about. And that I've been lucky enough and dedicated enough to devote my career to that.
It's good for you, Arthur. That's really incredible.
Thank you.
I can't say to you, Arthur, are you in it for the money? Because I know the answer.
Right.
The answer is no. Okay?
Exactly.
How do you decide? Someone calls up, John Doe, Jane Doe, right? They've already called lawyers about a case that they think is worthy, but the lawyers say, I'm sorry, we can't take the case because we can't justify it because there's no money in this case. So how do you, as a public interest lawyer, how do you decide to take a case or not take a case?
Well, the first thing you have to do is make sure how big an impact it will have if you succeed. If we get called by people who want to sue the CIA for putting transmitters in their brains, and that's why the private lawyers didn't take it, well, we're not taking it either.
Okay. Well, I'm glad to hear that. I'm glad to know you have some standards. Okay.
Exactly.
So what is the deciding factor then for you?
The critical factor is what kind of a difference the case will make. It has to be a case that not only will help the actual clients in the case, but will help the public generally. For example, is there a defective product out there that is endangering millions of people? Is there discrimination going on that is affecting hundreds of thousands of people? Is there some danger to the public or some absolutely outrageous wrongdoing that needs to be corrected whether or not it makes any money?
Can you give us an example of some type of discrimination case you say that you took on that because you decided it would make a difference?
Well, sure. Let me actually start right before I joined public justice. I told you I wanted to be a public interest lawyer since I was 14. I was in private practice for 4 years in Philadelphia.
But you weren't a lawyer at 14.
No.
Okay. Okay. So we're moved along in your life.
Exactly. And at this board meeting in 1982, to my utter astonishment, I learned that there is a public high school in Philadelphia that excludes girls.
What year is this again?
1982.
82.
Yes. So I'm shocked. And I say, how is that possible? And they say, well, they have a legal justification for this.
What?
I said, what is that?
There's a justification
Yes.
for excluding women from a
Yes.
public school.
And you'll love the justification.
What
it
is it?
We have a separate but equal high school for girls.
What? Are you serious?
That was what I said.
Separate but equal
Right. And my
for
jaw
girls in
dropped.
1982?
Exactly.
Oh my
and I
gosh.
said, how is that possible? You know, we said, well, we sued over that 5 years ago and we lost. And I said, how could you have lost a separate but equal case? Brown versus Board of Education, 1954, civil rights, no such thing as separate but equal.
Right.
And they said, well, the federal district court judge agreed, and that's why he ordered the girls be admitted to the high school. But the high school appealed. And it got a ruling from the Court of Appeals that said, well, wait a minute. There's no such thing as separate but equal for race. But for gender, we have separate bathrooms, we have separate athletic teams. We're not going to say you can't have separate high schools if they're really equal. And the U.S. Supreme Court took this case, and Chief Justice Rehnquist had a conflict of interest, so he couldn't sit. The other 8 split 4-4, which left the girls out, but no national law. And I come along 5 years later, and I learn this, and I say, look, I've only been...
Wait, let me ask you something, because I just want to make sure I understand this. So, okay, so you're looking at this case, which basically was a loser, okay?
They'd already lost it
They
5
already
years
lost.
ago.
Okay,
Right.
5 years before you show up,
Right.
okay? They lose a case, and there's this United States Supreme Court case that basically says ixnay on no...
Well, they didn't rule. The Supreme Court split.
Before this.
Right.
On separate but equal,
Right.
saying you can't have that.
Right.
Okay. So we have a Supreme Court decision saying no, right? They lose this case, and then somebody walks into your office with the same case?
Well, the ACLU, at their board meeting, it comes up, somebody walked into their office with this case. And I said, if my law firm will let me take this case, I've only been a lawyer 2 years, but if they let me take this case, I will take this case.
So you're deciding, here you are 2 years out, okay? So you're now like 16 years old. No, seriously,
Right.
you become a lawyer, you're
Right.
you're a
Mid-twenties.
qualified lawyer,
Right.
you're definitely mature now.
Yes.
And you decide as a young lawyer that you're going to basically roll the dice on this. Right?
Well, to me, what I say to them is, look, the whole premise of all of this is that the boys and girls high schools are equal. No one has ever looked at the facts. I know how the world works. If we take on this case, we'll find out, we'll look at the facts, and the boys' school, I guarantee you, is
Wow.
going to be superior. And if it's superior, then they're not separate but equal. They're separate and unequal, and you can't keep the girls out. And that's how I convinced them to let me take the case, and within a year, we won it and got girls into the high school in Philadelphia.
Congratulations. I mean, it
Thank you.
just, you know, I'm sitting here, I'm like dumbfounded, okay, that in 1980s, this is happening, that
Right.
women are not getting the same education
Right.
as men. It just, I'm almost speechless.
Well, in athletics, what's happening in athletics throughout this country is just like what's happening at Central High School in Philadelphia. You have separate programs for men and women. They're supposed to be equal under
Right.
the law, and they're not.
Okay.
Women are being discriminated
Well, let me
against.
ask you this though. I understand what you're saying. There's, you know, the idea of they shouldn't be separate, you know, when they're not equal. Okay, so here you are. You're looking at these cases, but what is it that drives you to take this case? Is it that you see the national significance of the outcome if you win? Is it that you think you can process this case financially? I mean, what is it? What are the components of deciding? I mean, these are monumental decisions that you've accomplished, but you know, sometimes we look at things after the fact, right? We go, oh, that was great. It's like a football game. Oh, we knew we were going to win by 3 touchdowns, right? But really, I mean, did you know or have in your heart some sort of sense that we can win this and we're going to get a great result?
Well, the first reason we take it on is because it's just wrong. It's outrageous. I mean, they've got separate programs for the men and women. In the high schools, separate programs the boys have way better. I have 3 sisters. What kind of crap is that? It's just dead wrong. Second is then, can we win? And my view as a lawyer is, if you can see a way to possibly win and you can afford it,
Yeah.
and it's about basic right and wrong, then you take the case.
Sounds great. And when you say
Thank you.
Title IX, that's the law that prohibits this type of discrimination.
Yes, it prohibits.
Federal law.
Yes, Title IX is a federal civil rights law passed almost 50 years ago that says no sex discrimination by educational institutions in the country.
Okay, now that's what's so interesting. It says no sex discrimination, and women are being discriminated against, as you said. So did that also transcend into other areas other than this public school, like sports?
Oh, well, so first of all, Title IX had an enormous impact. It's hard to remember, but 50 years ago, there were graduate schools that wouldn't allow women to go at all. There were graduate teaching positions that were closed to women. There were math and science programs closed to women. I mean, the impact has been enormous of the statute, but where it's gotten the most visible is sports and colleges and universities, because it's the only area of education where there are separate programs for men and women. They're allowed to continue. And so you can see visually, very clearly, and through the numbers, are they providing equality or not? So athletics has come to be the biggest focus of sex discrimination in violation of Title IX. Because they're separate programs, you can measure whether they're equal, and they're not.
We hear from lawyers who make a risk assessment on a case. They're looking at financial risk on a case. You don't look at financial risk. You're looking, it sounds like, as, is there a wrong that needs to be righted? And can I do it for you? Can I right that wrong? Is that right? Is that the way you look at it?
That is the fundamental question. Yes, we do have to be able to afford to bring the case. So it's not like money doesn't matter at all. And yes, if we win under Title IX, the school has to pay our attorney's fees so we might make money. But that's not what motivates us. It's taking wrong and correcting it. It's all about doing right. It's about doing justice.
Which is like, it sounds like justice, which is one of those hallmark things that we keep searching for in this business. So what's interesting, though, is it doesn't sound like it's so much about probabilities as it is about trying to get a certain result. And being a public interest law firm, you have the resources. You get to decide which wrongs you want to right. Is that it?
Well, yes, but the whole critical point there is, for a public interest law firm, the way it makes most of its money is through contributions from members of the public, because what we do is fight injustice and right wrongs.
Okay. Is there any example on sports?
Well, yes, there's an enormous risk assessment, and actually the history of the litigation proves it. So after we won the Temple University settlement after 3 weeks of trial,
right,
anytime a school would eliminate a women's team, I would get a call. And I'd go to the school, and it's basic risk assessment.
Amazing.
I would go to the school and I'd say, look, you've cut this 1 or 2 women's teams to save 50 to 100 grand a year. If you put them back right now, you make my clients happy, pay my fees, we're done. But if you make me sue you, it will be a class action on behalf of all of the women athletes and potential athletes at the school, for all of the ways in which you're discriminating against women in your intercollegiate athletic program, which we both know is probably every aspect of your athletic program. It's going to cost you millions to treat the women equally to the men. You're going to have to pay your attorney's fees. And since I'm going to win under Title IX, you're going to have to pay my attorney's fees. And the whole time, I'm going to go to the court and get an order restoring this team while the case goes on.
Amazing.
So you're not going to save any money. It's going to cost you a fortune. Do the right thing, the smart thing,
right,
by the calculations.
Right.
Put the
Wow.
team back. And that was what school after school did until 1992, when Brown University decided it wanted to fight.
What happened then?
So it went just like I told Brown University it was going to go. We went to court. We got a preliminary injunction keeping the teams in place while the case went on. They took the case to the Court of Appeals. Now, there was no case law then. This was one of the very first cases. We won every legal ruling in our favor. We go back to trial. On the eve of trial, Brown agrees to treat the men and women equally, but it still wants to fight about opportunities to play sports. So we go to trial. Not only does the judge order them to keep the 2 women's teams it's trying to eliminate, it orders them to upgrade from club to varsity status several other women's teams.
Wow.
We go back to the Court of Appeals. We win on every legal issue then. The U.S. Supreme Court refuses to take the case, and 6 years later, Brown University settles with a settlement agreement that stays in place forever, according to its terms. We don't know for sure, but we are told then that they're spending $3 million a year more on women's athletics than they were spending just to make women treated equally.
That's
They're paying
amazing.
their lawyers over $3 million, and we know they paid us over $1 million in the 1990s.
Wow.
And Ms. Magazine gave the president of Brown University its Male Chauvinist Pig of the Year award.
I'm surprised they didn't give you like this big picture in the center of the magazine.
Right. So,
You know?
whenever a school after that cancels a women's team,
Yeah.
I would go to them and say, look, you can either put the team back and be smart, or you can be like Brown University. What's your preference? And year after year, schools would put the teams back.
Yeah.
They stopped canceling them. Women's teams basically were not eliminated for
Okay,
over like a decade until, amazingly, last June, I get a phone call from my former lead counsel in Providence, Rhode Island. And she says, Arthur, you're never going to believe this. Brown just violated our 22-year-old settlement agreement.
Oh my God.
We have to get the band back together and go after
It's like
them.
the Beatles are going to go back on the road.
Right.
Oh my gosh.
And so, in the middle of COVID, from my home office, we go after them again. We force them to reinstate two women's
Good
teams,
for you.
get into compliance. While that's going on, William and Mary College, which had tried to get rid of women's basketball in 1991 until I
Right.
forced them to put it back, announced it's eliminating several men's and women's teams.
Really.
I threatened them, they put them back. Literally, it has now been a school a month for 10 solid months
Oh my gosh.
that we've had to threaten to put them back. Everyone but one has put them back. We're in litigation against one school, but otherwise, I'm doing 95% of my time fighting for women's rights and equal rights.
You must be, every women's magazine has to have a picture of you, right? Or you get like fan club letters.
So here's the critical point for everybody to recognize. I mentioned that Title IX was a civil rights statute prohibiting discrimination on the basis of sex. It prohibits against women and against men. Now, up to now, all of these lawsuits were on behalf of women because women are the ones being discriminated against. But amazingly, Clemson University was treating men and women equally in terms of opportunities to play sports. It was denying women equal financial aid and equal treatment. And it announced that it was eliminating its men's track and field and cross-country team, primarily black athletes. And I get a phone call. And bringing a civil rights case on race discrimination is very hard there because the Supreme Court has said you have to prove an intent to discriminate on the basis of race.
Right, right.
But under Title IX, because they're separate, you don't have to prove intent, you just look at the results. And the results were they were going from giving men equal opportunities to play sports to discriminating against men on the basis of their gender. And so I did something no one had ever done before. And typically you don't want to threaten a suit on behalf of the men because they'll say, oh, we'll make up for it. We'll cut a women's team too, which doesn't solve anything.
Yeah, yes.
But we come up with a strategy. And I'm going to say 8 months ago, on a Friday, I send the president of Clemson a letter saying, hi, I'm Arthur Bryant. I represent the male athletes. Unless you put the men's track, field, and cross-country team back and get in compliance with the law, I'm going to file a class action on behalf of all the male athletes and potential athletes at the school. The following Monday, my co-counsel in all of my other cases, Lori Bullock, sends a letter saying to the president saying, hi, I'm Lori. I represent all the women athletes and potential athletes at the school. And we know about the men's case, and we support that because we don't want you to discriminate against men, but we don't want you to discriminate against women either. And you're denying us equal athletic financial aid and equal treatment.
gosh.
And unless you give us equality, we're going to sue you as well as a class action. So we create Clemson as the first school in the country to be simultaneously threatened by its men and women for sex discrimination in violation of federal law. And surprise, surprise, Clemson puts the men's teams back, agrees to add 2 more women's teams, agrees to give women equal athletic financial aid and equal treatment.
Arthur, you've received accolades, National Law Journal, other publications. I mean, what you have done has done so much good for men, for women, for sports, for schools, education in the United States. It's so rewarding for you. It must be so gratifying for you in ways that has nothing to do with money.
Oh, totally. I mean, look, first of all, it's fun. You're fighting for justice and you're winning and you're helping change the world for the better. What could be better as a lawyer or as a person than that?
Well, you are, again, you are one of a kind. Okay, you really
well,
are.
thank you. I wish there were more.
I know it's great, but what about what are the other things? I mean, other than you know, in your practice, you have sex discrimination. You said you do products. Do people come to you about things like ordinary things, like everyday products that might harm people? Do you decide to take those cases?
Sure. Well, if the case is right, and if the case will make a big enough difference, and the wrongdoing is outrageous.
So
enough.
give us an example. Look, I'm proud of you. Listen, I really, I feel like I could hug you and say thank you on behalf of everybody, especially all the women and male athletes in the country.
Well, so let me talk about one that is actually a current risk to millions of people throughout the country. The single most popular rifle in this country is the Remington 700. It has a defect in the trigger that
Wait,
is
has now or has had?
It has had since it started being sold now close to 50 years ago, and it has still to this day a defect in the trigger. I am not making this up. It will fire, the gun will fire when no one pulls the trigger.
How is that possible?
There is a defect in the trigger that a piece of dirt or gravel could get in there where the trigger is poised to fire, but it hasn't fired.
Oh
and if the gun is bumped, it'll shoot on its own. And talk about a horrible, horrible situation. We learned about this because I was approached in 2010 by an incredible man named Rich Barber, military man, NRA member, lives in Montana. And he calls me and he says, Arthur, I need your help. He said, let me tell you what's happened to my family and I already. He said, I'm a hunter. I go out hunting with my wife and 2 kids regularly. We went out in 2000. My boy was 9, my girl was 12. And we go out hunting and we come back, we have Remington 700s. And my wife is cleaning her rifle. To clean the rifle, you have to take the safety off the trigger. Her hand is nowhere near the trigger. She takes the safety off. The gun fires on its own. It shoots, the bullet goes through a trailer, bounces off a wall, and kills our 9-year-old boy.
Oh my God.
Exactly. He says, we were devastated.
I'm devastated listening
Right.
to this.
said-
It's horrible. I mean,
Right.
you can't even express it in words.
Exactly. He said, we were devastated. You know, we're gun people.
Yeah.
You know, we support the Second Amendment,
Yeah.
but guns aren't supposed to fire when you don't pull the trigger. He said, and I got a lawyer, and Remington, because Remington, it turned out, had been sued about this in the past, and I found a lawyer. Remington agreed to pay me right away. And I said, well, it's not about the money. I want this trigger fixed. And to their credit, he said, they agreed that they would work with me, he says, because I know guns, to design a safe trigger. So we reached the settlement quickly in 2005. I go to their R&D headquarters. We come up with a design for the new safe trigger. And my understanding is they're going to go in production. And when they go into production, they're going to do a recall of all of the now over 7.5 million out there, I think was the number.
Oh my gosh.
I could be wrong on the numbers. I apologize if I am, but it was millions of guns out there. And he says, and what happened in the meantime is that Remington was bought by a hedge fund. And they went into production this past, short time ago. And I went to them and said, what about the recall? And they said, we're not doing a recall. You don't have anything in writing require us to do a recall. He said, and I can't live with that. I pledged to my son, in my memory of my son, I'm going to get these guns recalled. He said, so I started trying to find out what could I do? What did they know and when did they know it? And I discovered someone told me to go look at a case file in Montana federal court in a case that took place 5 years before my son was shot. And I went to the courthouse, and the name of the case that I was told to look at is Sealed versus Sealed. The entire court file has been sealed. I can't even tell you it's a Remington case.
Seal versus seal. In other words, not available for public view versus not available for public view.
Exactly.
In other words, like locked up.
Right. You can't tell what the case is about, he says to me. I've been told it's about this Remington rifle. And I know you at Public Justice have this project to fight secrecy in the courts. Will you help me get this file unsealed?
Oh my
And we
gosh.
did. And we got the
Wow.
entire court file unsealed. It turns out it's a case called Alexich versus Remington. the same thing had happened to another person 5 years earlier.
No.
So we get the documents unsealed in 2010, and Rich Barber takes them to CNBC, as well as going to the Montana State Legislature and getting an anti-court secrecy bill passed in his son's name, the Gus Barber Anti-Court Secrecy Bill in
Right.
Montana. CNBC uses the documents to do a special, Remington Under Fire.
Right.
And Rich Barber thinks they'll recall the gun now.
Right.
Remington responds not by recalling the guns, but by doing a counter documentary that costs it over $2.5 million that says CNBC doesn't know what it's talking about. These guns are safe. You should keep using them. No problem. I learned this because my involvement stopped when I got the court file
Sure.
unsealed. When Rich Barber comes back to me in 2015 and he says, Arthur, they've not done a recall. I'm going to force it. And so I've become an expert witness over time because people are still getting shot and killed by this gun, and they get sent to me.
And I say expert witness, like you go to court, you sit in the witness stand, you testify. And what do you testify about?
Well, Richard Barber did not become a testifying expert. He became a non-testifying expert because they knew if he testified as an expert witness, what people would say is, well, you're just out to get Remington because their defective product killed your son.
Right.
But he has all the information. So as a non-testifying expert witness, he can get access to all of the new documents that are discovered and more documents. And he says, Arthur, I got a class action filed on behalf of all of the owners of this gun, over 7.5 million of them still out there.
Wow.
And there's now been a proposed settlement reach where if anybody makes a claim, they will get their gun retrofit with a safe trigger for free. And I say, well, congratulations. He said, no congratulations. I said, why? He says, because these lawyers who I helped work agreed to secrecy. And I am petrified that Remington will announce the settlement has been reached and you don't need to make a claim because these triggers are safe.
Oh.
And he said, so here's what I did, Arthur. I told them, I have all of your documents. I know as an expert witness, I'm not supposed to disclose them, but I don't care. My son's dead.
That's right.
And I'm going to make them all public. And
That's
they've
right.
said to me, Mr. Barber, you can do that. We know we've already ruined your life, but we're going to ruin the rest of it. If you make it public, we will sue you for contempt of court for violating court orders all around this country, making these documents secret. And he said, Arthur, you know me. I don't care. I can't get my son back, but I can save others.
Yeah.
I am ready to make these all public, but I'm hoping you have another way. And I said, actually, Rich, I think I do. And I went to Remington and to the class action lawyers, and I said, I have a new client as of last week, the Center for Investigative Reporting. And either you make all of these public, or I'm going to go into this class action settlement, and I'm going to move to unseal all the documents. So make them public, because you're going to lose if I go to court. And amazingly, they agreed. They make all the documents public. We post them on the web, create a website, www.remingtondocuments.com, and post that they've known for decades that they repeatedly considered recalling and decided it wasn't worth the money, let the people keep dying. And we think now we've accomplished everything we can. And then Richard Barber gets a call from a man named Roger Stringer. Roger Stringer calls Richard Barber and says, Mr. Barber, I'm in your situation. I need your help. He says, what are you talking about? My wife are out, and I come back, and my son, 14, Zachary, says, I was holding the rifle. I didn't pull the trigger. The trigger went off, and it blew my brother's brains out.
Oh my God.
He said, and Mr. Barber, I didn't believe that he didn't pull the trigger because guns don't fire when you don't pull the trigger. And my son was prosecuted for murdering his 11-year-old brother
Oh my
and has been in the Mississippi State Penitentiary for the last 5 years, and I testified against him. And I've now learned these guns will fire when you don't pull the trigger, and that you are an expert, and I need your help to get him out of jail.
Right.
And we got the information to CBS. It went on 60 Minutes. Zachary Stringer is now out of the Mississippi State Penitentiary.
Oh my gosh.
But those guns are still out there, and they still endanger people throughout the country. So anybody who has any one of the, not just the Remington 700, but all of the dozen models listed on www.remingtondocuments.com, check. If you have one of these guns, do not use them unless you get the trigger replaced.
Hey, Arthur, this is, I mean, it's obviously very, very impactful. All I can say is, the work that you do is so important to not just your respective clients, but our entire country. And all I can say is, thank you so much for being here today. And thank you again for joining us. And I hope you'll come back and join us again.
It would be my pleasure.
Great pleasure.
Thank you.
Thank you.